Well, welcome, ladies and gentlemen, to the Institute of Advanced Legal Studies. I'm Carl Stitchin, the Institute's director, and it gives me great pleasure to welcome you to this very special occasion, the launch of a new series at the Institute, Judicial Conversations, which has been organized by Professor Les Moran, Emeritus Professor of Law at Birkbeck, University of London, and a Senior Associate Research Fellow here at ials. I was delighted when Les agreed to bring this successful series to the Institute, also under the auspices of the Society of Advanced Legal Studies, the Institute's Friends Group. SALS is the official society of the Institute, representing the Institute's extended academic community and comprising scholars and professionals from the wider legal world. I would encourage you, those of you who are members of that community, if you have not done so already, to become members of SALS, and membership is free, in order to become part of our wider community of supporters. Further information can be found on the Institute's website, or you're also welcome to speak to my colleague, Yvette Rathbone, who's at the back, after tonight's event. So once again, welcome to the Institute. And now over to Professor Les Moran to introduce this evening's event.
Thanks very much, Carl. Just by way of extending Carl's introduction to the Judicial Conversations series, I just wanted to add a bit more background to that project. When I first contacted Carl, I made a proposal with 4 or 5 objectives. One was to promote understanding of the work of members of the judicial family. The second was to promote dialogue between members of the judiciary, academics, legal practitioners and the wider public. The third was to promote scholarly research on the judiciary. Fourth, to engage wider audiences. And fifth, to complement the work that was already going on in the Institute that included judicial speakers and judicial topics. And I think the conversation that's emerging around the possibility of constitutional change has made this conversation urgent, particularly urgent. Certainly the opening salvos that I've been reading about the parameters of that review and the factors motivating it suggest that there's an urgent need for greater understanding about the role of the judicial family in our contemporary world. Topics that we've focused on include conversations with judges about the art of writing judgments, discussions about the changing roles of the judiciary in the courtroom, for example, the tension between the growth of managerial tendencies in contrast to the role of the judge as the refugee, debates about judicial diversity and judicial appointments, and general conversations about the role of or the appearance of the judge in popular culture and popular understandings about the role of the judge. It's a particular pleasure to welcome Lord Dyson as our first guest in the ials series. As I'm sure you all know, that after a successful career at the bar, Lord Dyson was first appointed to a judicial office in 1986 as a recorder. He became a judge in the High Court of England and Wales in 1993 and stayed there until 2001 when he was appointed to the post of Lord Justice of the Court of Appeal of England and Wales. In 2010, he joined the new Supreme Court and remained there until 2012, when he returned to the Court of Appeal as the Master of the Rolls. As you know, the Master of the Rolls is the head of the civil justice system in England and Wales. But I think that title doesn't do, sorry to say this, justice to the incredible diversity of that role, because the Court of Appeal is, I think, in the vast majority of cases, the final Court of Appeal, so it has a huge agenda in terms of dealing with appeals. Those appeals cross the whole diversity of civil justice. In addition to that, the role has a huge amount of managerial and administrative activities attached to it. So it's incredibly demanding in terms of the role, but I think from reading Lord Dyson's memoir and talking certainly to the current master of the rolls is an incredibly rewarding position to hold. Lord Dyson continued in that role until he retired from judicial office in October 2016. Now, subsequent to his retirement, he's not put his feet up and spent countless hours on a sun-drenched beach or walking in the mountains, which I know is one of his passions. He's been incredibly busy. In 2017, he took on the role of Treasurer of the Middle Temple. After retirement, he re-established a practice at chambers in 39 Essex chambers and has developed a practice as a domestic and international mediator and arbitrator. And subsequent to his retirement, he's published a number of books, one of which is the focus of tonight's conversation. It's a memoir that was published by Herz in 2019, A Judge's Journey. Before we embark on a conversation about that memoir, let me also introduce you to my fellow host this evening, Ruth Hertz. Again, it's a great pleasure and an honour to welcome Ruth to ials. She too has a fascinating judicial career. For much of her judicial working life, she was a judge in the youth court in Cologne. For a number of years, she took a break from that role and performed the role of a judge in a very different setting. She was a judge in a hugely successful reality TV show, court show in Germany. She also has been a prolific author, scholar and reformer, and this is a memoir that she published shortly after I think you finished working as the judge in reality TV show. Yes? Yeah. So the format for this evening is for Ruth and myself to have a conversation with Lord Dyson about this fascinating memoir. The plan is to let that conversation roll for about 40 minutes and then to open it up to questions from your good selves. We hope to close by 7:30 and there are some light refreshments at the back for us to carry on the conversation subsequent to that. So let me begin by handing over to Ruth.
Oh, thanks. So, John, I was wondering because judges usually don't write memoirs. It's rather rare all over the world for judges to talk about their own personal life, how they led their life, being a judge, not being a judge, no longer being a judge, and so actually my first question is what made you write this book? Why did you embark on it? Because it's quite a daunting task. So what was the first?
It didn't feel daunting when I was doing it, but I mean, in retrospect, I wonder whether I perhaps was very wise in some of the things I wrote. But I was determined to write a very honest and open account, and not. I felt if I was going to do this, then I had to be true to myself and tell the world as I saw it. And a lot of people said I was quite brave to do that. Why did I do it? A number of reasons, really. I suppose first, I think many people, when they get to a certain age, feel they want to set out something about their lives for their families. Mm-hmm. And I regret that I never had the benefit of anything like that from my parents. And I've met so many people who feel that loss, really, not knowing about their parents' lives. But this is not really about my parents' lives, although the first two chapters are about their lives, because inevitably your parents shape your lives anyway. So that was number one. I wanted to set out the story for my children and particularly for my grandchildren. And one of the great joys for me was I'm Jewish, and last autumn, the Jewish New Year, I presented a copy of this book inscribed by me to each of our 5 grandchildren. And whether they will ever read it, I don't know. I hope they will. But I have no expectation that they will read it for a very long time, except that the little bit, I know that there are 1 or 2 bits about my school days when I was no good at cricket, and one of my grandsons is a very good cricketer. So he alighted on that bit, and I think they pick out little bits. So first reason is a memoir for the family, but that doesn't explain why go public.
Exactly. Would have been my next question.
Yes, well, why go public? And there are a few reasons for that, really. First of all, when I retired as Master of the Rolls in the autumn of 2016, I had a valedictory, like most senior judges have when they retire. And my speech, which I thought quite hard about, was quite a serious speech. And the typical sort of archetypal valedictory speech of senior English judges, they're quite light, they are self-deprecatory, they are very English affairs. That was not what I wanted to say. Although I feel in many ways intensely English, but I also am very conscious of my European and Jewish roots and all of that. And I'm incredibly grateful to this country, and I say this in the book. And I certainly said it in that valedictory. I'm very, very grateful to this country for the fact that my father's parents were allowed to come here just before the end of the 19th century with nothing, no education, no money, and allowed to settle here. That my mother, who was born in Bulgaria and married my father in circumstances which are fascinating, but probably tonight isn't the time to talk about them, but I've described them in the book. And she was a Middle European, really quite well-educated person. And my mother married my father just before the outbreak of the Second World War. So she came to England, because my father was English-born. And her mother was less fortunate. I mean, a number of members of my mother's family perished in the Holocaust. And her own mother ended up in Bergen-Belsen for 6 months in 1944, and then managed to get to Switzerland, again, a complicated story. So I'm intensely grateful to this country for allowing my family to settle here. And although I personally have hardly ever encountered anti-Semitism, and I have been allowed to flourish in this country, and other members of my family likewise, but I've never ceased to be grateful, and so I wanted to express this in my valedictory. And people didn't know much about my background, and even today, people say to me occasionally, they talk about that speech, and they wanted to know more, and they were incredibly moved by it all. So that was, I suppose, that was one inspiration, and then there were various things I wanted to say. I wanted to tell the world what it's like being a judge, and to do that in an open and honest way, because there's a lot of mystique attached to being a judge, a lot of mystery, and I don't see why that should be. Judges are public servants doing a very important job in the public interest, and I think people are entitled to know. And the last thing, and then I will stop talking, the last reason was that there is a chapter in the book, I think called something like being a Jew in this country. And I there talk about things quite personal, about the insecurity that I, to some extent, have, and which I share in common with so many Jews in this country who are totally integrated, as I am, who have been incredibly successful and are seen to be pillars of the establishment, and yet still suffer from this kind of residual insecurity. And non-Jewish people are astounded when I tell them this, and they're incredulous. And I felt it was important to say this publicly, and I've had so many, mainly Jewish people, responding to my book, saying that a lot in the book, in particular that, has resonated with them. So there's a whole concatenation, if that's the right word, of factors which led me to write it.
Still, as Les has just said, I've written one myself, for completely different reasons, I think, but than yours. But writing about yourself as a judge, does it take away some of the mystique, as you would, the gravitas, or the lack of being unbiased, or making you maybe making judges as a whole more vulnerable because they may actually have preferences. Once you start talking about yourself, you reveal preferences, ways of living, religious belonging, and all these kind of other things, which one of the reviews that came after my book, I wrote it ages ago, so was it's all very well, and we like, she's a very committed judge and all that, but do we have to know all this? So actually, does it take away from our judicial position, judicial charisma, and whatever else belongs to being a judge, when we start talking honestly, as you say? I don't know how honest we are actually, because when you write about yourself, it's always it's all sorts of things, not only honesty. But but does it take away from the judicial position and judicial power and judicial gravitas or whatever?
Well, I have a number of answers to that. One is that I don't want to give the impression that this book is just about my deep innermost thoughts and feelings. It isn't.
No.
I mean, you've read it, and most of it is describing factually what happened, and it's talking about some of the cases and so on. So I think it would be wrong to give the impression that this is a book which is sort of bearing my soul, my innermost thoughts about God knows what. It isn't. That's number one. Number two is, I understand the argument, but I don't really agree with it. I think that we're all human beings. I mean, there's no point in pretending that judges are not human beings. And okay, I mean, I've said a little bit about myself and my background, and I'm not well equipped to decide whether that has influenced the way I decided cases. I think it may well have done a bit, because I think I was perceived, I think, as being a somewhat liberal judge. I must say I'm very pleased if that's what the perception, but some people might not agree with that. Some people might think that he was too prone to deciding cases against the government, for instance, although I don't think I did particularly. But there's no point in pretending that we're not human beings. In fact, I think it's important that people should know that we are human beings.
I agree with you completely. Otherwise, I wouldn't have written mine. So it's
the mystique is, it's the office, and it's what judges do that give them their aura of power. Yes. It isn't really whether they they love classical music or they like walking on the mountains or something. It is the gravity of the issues that they have to decide.
But it's also the robe and the buildings of the court buildings, and the language we use, and the spaces in which we use, which we act.
Yes.
But that's what builds the.
That's there for everybody to see, isn't it? But your question was, by writing such a book, am I doing something to kind of take away the aura, the power? Yeah. I don't think so. No. I think the power comes from what you do.
But I think it's a refreshing approach, and one that I think many judges, certainly in the past, have not adopted. So I remember reading in one piece of scholarship how judges often had a big archive that was generated during their working life, but one of the first acts that they did on retiring was to destroy all the papers, so that no one would be able to look at them 20, 30 years down the track to discover the reasoning behind the judgment.
I think we've got to be a bit careful here, actually, because I don't know whether we're going to talk about Lord Hope's diaries. But I do. Probably many people in the room will know, but maybe not everybody, that Lord Hope was the deputy president, ended up being the deputy president of the Supreme Court, and he has published 5 volumes of his diaries going back to when he was a lawyer in Scotland, I think. And I overlapped with him for 2.5 years in the Supreme Court, and I had absolutely no idea that he was keeping a daily diary on who said what to whom during the discussions, discussions which I thought it was axiomatic were confidential. But he seems to have taken a different view. I think he's been heavily criticised in the quarters. But so, his diaries are there. He's quite the opposite. He's not somebody who's destroyed everything. He kept it all, and then he's published it all. So he would have said, well, and he said some extraordinary things. I have to say I haven't read the diary because I haven't bought it almost on principle. I think it's so wrong that a judge should breach the confidence. I think it seems to me obvious that when judges are discussing how they think about a case before the judgment is written, and everybody changes their mind and all that sort of thing goes on, and that should be confidential.
Did you write diaries whilst you were in practice?
No.
Because as I was reading the book, where does all this detail come from?
Yeah.
You must be an avid diary writer.
No, I didn't keep it. I've always had a little pocket diary, but that's just an engagement thing. I kept press cuttings of anything that was of any interest, but there wasn't all that much of that. When I was Master of the Rolls, I had a private secretary, and so for those 4 years there was a diary, and so that was fairly well documented. But beyond that, I don't really know. But I did not keep a Lord Hope kind of diary at all.
It's interesting. I suppose it feeds into another question that I wanted to ask you, which was about the process of writing a memoir. Judges spend a huge amount of time writing. They're incredibly skillful at writing, but those skills tend to be honed around producing a particular type of literature, judgments. And for me, the thought of attempting to write a memoir is just too daunting. I wouldn't know where to begin. I do a lot of writing, but I can't imagine where I would start. And I know the empty page is always incredibly intimidating, but you tell some very powerful stories. So I was wondering whether or not you found writing a memoir, in contrast to writing a judgment, was very different, very intimidating, or whether you found that the skills that you'd honed and refined in the process of your long and venerable judicial career came to your aid and helped you in this process of writing a memoir.
It's a very interesting question. I hadn't thought about that before. I mean, I didn't find it at all daunting. I did it quite quickly. It sort of just tripped off. I mean, it didn't trip off the pen because my rather poor word processing skills, but I did it. It didn't take me all that long. I think I started in about March of 2018, and I finished before the end of the year. And I've been doing some other work in between. So it just seemed to flow. Whether the style is different, I don't know. I've always thought that writing judgments, the two guiding principles for me, I mean, obviously try to get the right answer, but leaving as far as style is concerned, one is to try to be as clear as possible so that nobody is in any doubt as to what you're saying, what you're deciding, why you're deciding it. And secondly, to try to be tight and succinct and not verbose. Now, I've always hated verbosity. I think this must go back to my Latin days or something like that, but I've always hated verbosity. I mean, I'm in the middle of writing a massive, I don't know why I've got involved with this, but it's a massive, incredibly difficult auditor's disciplinary case. It's a hugely important case. And the documentation is vast and the submissions go on for hundreds of pages. And I am doing quite a lot of copying and pasting. That's something I never did as a judge. But so I'm doing this copying and pasting, but then I'm slashing it because I've got to prune it and keep it down to the essentials. So whether that style of writing judgments to what extent that's been carried through to the book, I'm not sure. I hope it hasn't been I hope some of it has. I mean, people have said to me that it's very pacey. It moves along at quite a lick, which means that it's. I mean, I think that's good. I mean, it means that it's not verbose. I don't waste words.
Yeah.
I try to make it occasionally a little bit, as you said, powerful or a bit dramatic here or there, in a way which I wouldn't in a judgment.
Right.
So there are differences, but I've never stopped to actually kind of articulate them.
Yeah, but maybe also because that's in your character. You're not going to chat along. You're going to say what you have to say, and that's it. And you say that in your book. You say that in court.
Yeah.
And so that's a kind of character trait which I like. But
Well, anyway.
yeah. Well, what I like, especially when I was reading some of the cases you were describing, and when you do say, I felt sorry for this person, or I was sad for her, or for him, and then you say, well, but I have to stick to the law, and that's what I couldn't. So the law trumps your feelings,
yes.
and that's something I think in the judicial work you have to get used to. I mean, I remember also, of course, many cases where I could see, mine was in a criminal court, so I could see the defendant looking at me, searching my eyes, trying to get, my sympathy, my empathy. And in the beginning of my career, I actually responded a little. And then I realized that they were, getting their hopes too high. Just because I'm friendly or I react to this kind of asking for empathy, doesn't mean that I can decide anything. I have to decide what the law demands in this case. Of course, we all have leeway. Judges have leeway, and they can change things. I'm sure much of our personality goes in, and like you, I'm Jewish too, but my family was living in Germany until 1933, and for many hundreds of years. So they weren't immigrants in that sense, because they'd been there. Well, we have a family tree going back to the 17th century at least. So I can, I feel, okay, this is a country I'm not going to be grateful. Of course not, especially not Germany. There's no reason to be grateful to Germany for what they did to my family and my family tree, and everybody had to flee in the early 30s. But I do know that I'm an insider and an outsider. That's something that you are describing in different words.
Yes.
In a way.
Yes. I've always thought you have to be honest as a judge, and sometimes you have to make very hard decisions, and I always tried to conduct a very fair hearing and make sure that, particularly the party who loses the case, felt that they'd had a really fair hearing. That was crucial. But you have to decide cases according to the law. But as you say, there's quite a lot of wriggle room in certain sorts of case, exercise of discretion. The one thing I could never abide, and I'm afraid quite a lot of judges did and probably still do, is that they frankly distort the facts in order to arrive at what they think is the right answer, and they worse than that, they try and make their decision appeal proof by wrapping it all up with findings of fact. And we all know that there are judges who do. I'm sure there are still judges who do that, but there certainly were when I was at the bar. And in my view, it's totally wrong. But having said that, there are grey areas where you can justify going this way or that way, because it's really fairly finely balanced. And in those sort of cases, I think there's nothing wrong at all. Indeed, I think it's to be commended that you go the way which accords with your sense of justice in those sorts of cases, but not where the answer is plain. The law requires you to go some other way, or frankly to make a finding of fact contrary to what you think is just. It would be a perverse finding of fact. That, to my mind, is unacceptable.
In the acknowledgements, you describe the process of producing this, or the driver behind the memoir, as offering a full account of your life. So I was interested in this phrase, full account, because it's almost as if you're sort of auditing your life and presenting it for us to read, which is, as you've described it, really. But I think my question is, and I think it's something that you've touched on already. It's this idea that it's impossible to give a full account of your life. There's a wonderful history, a sociological history of Paris, and it starts in a square outside a church and begins to describe as much as possible of the detail of what's happening in that square. And at a certain point, maybe 20 pages in, the author says, this is impossible. I cannot describe just one square. So again, the task of calling your life or writing an account of your life strikes me as being an impossibility. So again, my question is really about what sort of factors inform the decision-making process. I put this in, but I won't put that in. I'll put an emphasis on A, but diminish the significance of B and C.
I really find that an impossible question to answer. If I said in the acknowledgement that this was meant to be a full account of my life, well then I shouldn't have used the word full. And you read it very, very carefully. But I think I've tried to give an account of the essence of my life, really. You can't, it's impossible to give a full account of your life. And I had a real task to decide how to deal with the cases, both as a barrister and as a judge, because this was not intended to be a massive tome about all the cases that I decided or been involved in. It simply wasn't that kind of book at all. And so I had to be highly selective. And I deliberately, I don't know whether I said this but in the book, but it certainly is the case, I deliberately did not focus on cases which I thought were important for the development of the law. Because you go to a legal textbook on the law of torts or contract or whatever it might be for that. This is a memoir. And so what I did was I selected a smallish number of cases at each level, and which I thought were of general public interest. And I didn't describe them in enormous detail, but the idea was to give a flavour to the general reader about what sort of cases and what sort of issues I had to decide and how I decided them. Now, some people have criticised the book because it's too brief on that score. Well, that's a fair point, but it wasn't meant to be that kind of a book.
Yeah.
So it's meant to be about me and my career, giving a flavour of the sort of things I did more than anything else.
Do you think being Jewish has played into your profession, into your decisions? Because you do put an emphasis on being Jewish, Jew in England, your family history, your own background, your preferences, and I was wondering, how do you think that? I mean, it must have come in some way because that's you. So, how do you think it did play into?
Well, I have really no idea how it played. I think I suspect it must have, subconsciously have had some influence on me. And in that, for example, some of the cases involving claims by refugees, where I think, a lot of claims by refugees simply have to fail because they don't satisfy the criteria. But there have been some cases where I don't know. I suspect I would have to subject myself to a psychoanalyst, and that's not something I would wish to do. I've never done, and I don't want to. But I suspect that a psychoanalyst might prize out of me an answer to your question. I don't really know.
Yeah. Because also it's not only it's what I mentioned before, it's also this feeling of being an insider and an outsider, and that must colour maybe not the Jewish side, but it must colour your thinking when you see things also from the outside. You see structures in society, you see tastes or attitudes in a society. If you don't completely belong to a society, you see these things more than more than if you do belong, maybe.
Well,
I'm not sure.
I do feel I'm a fully paid up member of our society. I don't feel an outsider of the society. I'm totally comfortable in any environment, frankly, in our society. I mean, I did inwardly chortle a little bit when I used to go to the Buckingham Palace garden party, and when for the last 6 years we were invited to the royal tent every summer, and so the Queen and the rest of them, they kind of mingle, and you have these really quite, how can I put it without, I must be careful and choose my words. You don't really have conversations with them. In fact, you're not supposed to have a conversation with the Queen. I think you are allowed to have a conversation with the others, but you don't really have a conversation in that environment. But I think that there were times when I did kind of inwardly chortle to myself. I'm wondering, what would my grandparents have made of this, for instance? And they would have been, I think they'd been very proud. They would also have been astonished, actually. But I have never felt uncomfortable in those sort of environments.
No, I didn't. Yeah.
So if you say I'm an outsider, I'm not sure in what sense you think I might consider myself to be an outsider.
I can only speak for myself.
Yeah.
Things there where you don't belong, or celebrating Christmas. Everybody's about that around the Christmas time, and we don't have Christmas, and so I'm an outsider there. I mean, just simple things also. I'm not an outsider. I think that, I'm a judge. I was a judge in Germany. You can't be more, and that's also for you. You can't be more part of a country than being a judge. That's it. That's being the authority of saying what's right and wrong in a country. So you have to belong in many ways. I'm not talking about outsider as in that sense, and certainly not in my case, where my family, my father's side, was German for centuries.
Well, you, in a way, were much more of an insider, arguably, than I was, because my mother was born in Bulgaria, and my father's parents came at the age of 21 from Lithuania, speaking no English with no education. And it's remarkable, actually, and we're seeing this now with immigrants, different kinds of immigrants, Asians, for instance, and how rapidly they climb the ladder. And that's one of the great strengths of this country, that can be done.
Yes, absolutely.
This conversation reminds me a little bit of the work of the academics and judges involved in the Feminist Judgment Project, which is which is I think a really nice case study in how gender may inform different perspectives on the world, and how that is really fundamental in terms of what that might bring to the judiciary. That sense of justice, or the experience of life from a slightly different perspective, and it taps. I'm not sure it taps into the point you were making, but one of the, I think, important findings of the Feminist Judgment Project is the way facts are constituted, and how coming to a factual situation from a different perspective or with different life experiences can change not the facts but the emphasis that's given to the facts, the priority of one fact over another, and often that has profound significance in terms of how those facts then meet the law and how the two interact and the final outcome.
Right.
Yeah.
And that does colour. I mean, everything colours your attitude. And
Yeah.
being a different person, like a woman, when I was appointed a judge, I was one of 10% female.
Yeah.
They're all male, so it's a male
Yeah.
society that you're sort of dropped
Well,
into.
as you know, I mean, we've still got that problem here to a considerable extent. When I was Master of the Rolls, I had a large input into the appointment of people to the Court of Appeal. And when I arrived as Master of the Rolls, there were only 4 out of 36 or 8. And by the time I left, there were 9. Now that was still far too few, but I was very proud of that. And that was through encouraging women to apply, not through lowering standards or anything of that kind at all.
Yeah.
So, I mean, I've always been passionate about that. I suppose, as you've been talking, inevitably your personality, your character, your experiences colour the sort of person you are, and how activist a judge you're likely to be. There are some judges who will hardly ever decide a case against authority. I mean, it's just a fact. And then there are others who some people might say are a bit too willing to do that. And then there's a spectrum, and then there's all shades in between the two. Now, what is it that causes the first one hardly ever to decide against authority, and the other one to go very far the other way? I don't know, but it is a fact.
Yeah. I think it's a very pertinent fact in the context of current debate, but I think, as you've just indicated, incredibly complicated. There are no either-or solutions, either-or scenarios to determine which judge would be, in quotes, political, and which judge would be, much more compliant.
I'm very worried about what's currently about the rhetoric that's coming out of government at the moment. I think we've got to be careful not to say too much too soon, because we've got. This is not the first time we've had a government that's goes in for sound bites and immediate responses, and we've got to do something about this sort of thing. And we're in that. We seem to be in that situation now, where we've got a government which is very cross because it's twice been thwarted, most recently of the prorogation case. And Boris Johnson is clearly very, very angry about that. And quite a number of his ministers are. And so they're saying, who are these judges? All that's the usual stuff. We're going to do something about judicial review. There's far too much of it. In fact, there's been quite a significant decline, as a result of what Chris Grayling's procedural reforms, which he introduced about 3 years ago. And in fact, I was asked very recently if I would write something to publicly to say how important judicial review is to protect the rule of law and how important that is, etc., etc. And I said that I wasn't willing to write such a piece at this point in time. I just think it's premature until we know what the government is, because I think they're going to find it very difficult. It's just like when they were saying a few years ago that they wanted to get rid of the Convention on Human Rights, and we'll have our UK Bill of Rights, if you remember, and they had a commission and all, and they then started to realise that this is actually very difficult. It's all very well having these exciting sound bites, which go down quite well in certain quarters, but when you actually start to work out the detail of what it entails and what you're going to do and what you're not going to do, then it all becomes very difficult. And I said, I think now is not the time. I think one should keep one's powder dry until the government actually comes up with some concrete proposals. But I think they will come up with something, I think, with that.
This is maybe a sideline of that, but do you think that judges are somehow? Do you think that the media has an impact on judges too? Because the media is part of is also in this game, and sometimes, at least not the media in one way, but this headline, well, we'll all never forget about the judges being enemies of the people. Do you think that the media has an impact on us, on judges?
Well, I hope they don't, but I mean, who can tell? I mean, again, how do you measure these things?
Well, there are studies. I mean, in Germany, there's been a huge study asking every single, I think it was a complete, a total study of all judges in a certain time. And there have been studies done about that.
But what do the judges say? That I was influenced?
No, of course not. But then if you ask them, you have to. You don't just ask this one question if you're doing this research.
Well, I mean, you're have much more expertise in this area than I have. But I just wonder how easy it is to get really reliable data about this sort of thing.
Yeah.
If you ask a judge, are you influenced? Of course, the judge is going to say no, I'm not influenced.
Yeah.
So then you want to ask some more questions, and you may eventually prove that the judge actually, although he believes he wasn't influenced, in fact he was. But I think it, and then how many cases do you look at? And I think it's very, very difficult.
Very difficult. But what came out in this study was that the whole atmosphere changes in a courtroom. The judges were prepared to admit that the atmosphere changes in the courtroom when there's a lot of media present.
I can well understand that. I mean, I've experienced that myself. I mean, I've decided quite a lot of very high-profile cases, some of which I knew would go down really, really badly with the popular press and with the government. I mean, like it's one of the cases I mentioned, the deportation, the desire to deport Abu Qatada to face trial in Jordan. Abu Qatada is a dreadful man. Nobody, I think, very few people would disagree with that. But he was going to face a trial in Jordan, where the argument was that the evidence that he was going to face, the main evidence, had been obtained by torture. And the question was, in those circumstances, whether it was in accordance with Article 6 to deport him to Jordan to face such a trial, where he would not have a fair trial. And we decided that he would not be. And of course that was a very unpopular decision, because everyone said, this is an appalling man, we must get rid of him. And the same applies to other undesirables who would be at risk of facing capital punishment or torture, all these things. And we stand firm to our, I think, quite rightly stand firm on our principles, that we do not lend ourselves to that sort of thing. But you ask a lot of the popular press, and they will say this is ridiculous, and we know that. But you've got to be true to your judicial oath, and I think most people are.
Yeah, I would have thought you had to be pretty tough to be able to withstand that criticism. It's part of maybe the Benthamites, 1,000 eyes and 1,000 voices. 1,000 eyes are looking at what the judges are doing, and 1,000 voices are having a conversation about it. Yeah. But that doesn't mean to say the judges don't carry out their function according to their own.
I've always thought it was very, very important that when you're deciding these controversial cases, is to explain your decision as a judge, very, very carefully. And I always had a little conclusion at the end, because if the judgment was quite long, the journalists haven't got the time or the patience or interest to read through a 50-page judgment. Yes. But if you've got a half-page conclusion, and there you express in your words your conclusion, your reasons, well, that's you can't do more than that.
No, it's a very good practice. Perhaps at that point I can lift up the conversation up to other people in the room. I'll perhaps start here and then you next. Do you want to take one question at a time, or would you like to have a couple of questions together?
I don't really mind. Let's start with one at a time, see how we get on.
Thank you very much for this session, and also the fact that you did write the book, because I've spoken to some judges and they're very reticent to write a book, so thank you for that. My question is a horizon-setting one. How do you think that the Langleys, you said that you went in as master of the rolls and you had 4 females and it became 9. How do you think at 2020 and beyond, how do you think it will be developing?
Well, it's a bit that's a crystal ball gazing question, isn't it? Of course, I have no influence whatsoever now. But I do know that, and I'm delighted that in the last couple of years there's been a significant number of outstandingly brilliant female lawyers, both barristers and solicitors, who become High Court judges. And I have little doubt that those are the sort of people who will go further to the Court of Appeal, and 1 or 2 of them to the Supreme Court. I'm optimistic. I mean, Lord Sumption, who is given to sound bites actually. He said a couple of years ago it would take 50 years before women, but I don't know where he got that from. He just plucked a figure out of the air. But I don't actually agree. I'm not as pessimistic as that. I think all the signs are, particularly as I mentioned, there's been a lot of excellent women coming into the High Court now, and but I'm not going to say it'll be 20 years or 10 years or whatever. I'd really be very, very, very surprised if it's going to take 50 years.
Thank you.
Yep. You mentioned in your book that Lord Judge phoned you to suggest you might like to apply to be Master of the Rolls.
Yes.
And in spite of the fact that you actually, by your own admission, messed up the question on the relationship of the judiciary to parliamentary sovereignty, that you were nevertheless appointed, which is a very amusing story. But I was just wondering to what extent you thought the judicial appointments process had changed since the tap on the shoulder.
You've read the book very carefully. Well, it's changed hugely, of course. The tap on the shoulder was to modernise that, it looks appalling and inexcusable. It did actually, well, it wasn't very good on producing a particularly diverse judiciary, but it was quite good at sort of winkling out people who were not very much in the public limelight. And I don't know how they did it. They had a card system, and they had spies, and they had sources, which all very secret, and I have no idea, and there was no transparency at all. And in my own case, I was not a particularly well-known QC. David Neuberger was not a particularly well-known QC. So they did have their ways. But as to what happens now, I think it is obviously a very great deal better than it was then. I'm sure that it can still be improved. In fact, it's changed over the last, whatever it is, 15 years or so, I think it is, since the Judicial Appointments Commission came into being. The process of applying was extremely complicated and bureaucratic, and that put a lot of people off. I think they've watered that down and concentrated more on the essentials. But as I'm sure you know, my own experience has been very, very much limited to being on panels choosing people for the Court of Appeal and some of the top jobs like President of the QBD and the Chancellor and so on. And so for those big things, the panels of 5, and there are 2 judges and 3 lay people. So the thinking behind this was that the judges should not be over dominant and influential. the lay people are, in my experience, were of a very high quality indeed. I mean, you know, retired senior civil servants, academics, very impressive people. And they were certainly not people who would just cave into what the senior judges suggested. In fact, one of them, I remember saying to me, she said, you know, I'm very counter-suggestible. It was a word I hadn't come across before. But she said she was very counter-suggestible, so I learned from that, and I realised that I shouldn't go in too hard in promoting person or persons that I thought should be appointed. But I think I'd be dishonest if I were to deny that the two senior judges, when I was involved anyway, the two senior judges, were not very influential. Because of course at those higher levels, and I'm not talking about at the lower levels, where I think the input of the lay people is probably of greater importance and significance, about trial judges, where being an outstanding lawyer and being able to write an outstanding judgment is less important. It's not unimportant, but it's less important than having the personal skills to run a fair trial and deal with people and all that sort of thing. And I think it's for those sort of appointments that these excellent lay people probably, their input probably was more influential than at the higher levels. Because at the higher levels, you know, if I and the Chief Justice or whoever it might be was the other senior member of the panel said, look, you know, this person, we've read lots of this person's judgments. This person is an outstanding lawyer. This person writes brilliant judgments. It's quite difficult for the layperson to say, well, okay, but you know, that's just one aspect. Well, it is only one aspect, but it is a hugely important aspect at that sort of level. So it's quite a nuanced and complicated thing. Sorry, that's a rather long answer to your question.
Yes?
Are there cases which you now wish you had decided differently?
There are. I think I mentioned one or two of them in the book. I think one that I particularly recall was the case. It was a case called Amin, and it was all about, I mean, investigation. There was this Asian young man who was what's the Young Offenders Institution, Feltham Young Offenders Institution, and he shared a cell with a young man who murdered him. And the family of the deceased, Mr. Amin, asked for, there was an investigation, internal investigation, there was another investigation, and they said that there were shortcomings in the system which they identified, but the family was not satisfied. They felt that they should have had a full Article 2 compliant inquest with the family represented, and so on and so on. And this came, I can't remember what the judge at first instance decided, but it came to the Court of Appeal, and I was sitting actually with Lord Wolfe, who was at that point, I think, the Chief Justice, and Lord Justice Laws, and so it was a I hate using that phrase, strong court, but it was quite a strong court, and we just felt that there was no point in having yet another investigation. There'd been enough, so we dismissed the appeal, and they went to the House of Lords, I think it was at that time. I think this was pre-Supreme Court. It doesn't matter. And Lord Bingham, the great Lord Bingham, was in the chair, and they took a different view. They thought we were wrong, and they said that yes, there should be a full Article 2 compliant investigation, and there was, and it was conducted by a retired or a serving High Court judge, and the stuff that came out of that investigation, that inquest, was hair raising. I mean, the authorities had knowingly made this poor young Mr. Amin share a cell with somebody whom they knew was a racist, etc., etc. And none of that had come out in the previous investigations. So, I mean, Lord Bingham was proved to be absolutely right, and we were clearly wrong. So that's one example.
Yeah.
Hello. Thanks so much for this conversation. That was very interesting. My name is Thiago Lorenzini. I am a PhD student in criminology in Brazil. I'm here conducting research on judicial activism in Queen Mary University of London. And one of the aspects of my research, I am comparing the similarities and not among the judicial activist practices in Brazil and here in common law. And one of the differences that I can see it is how judicial activism here in the UK is most like that even when the rule of law is broken, they are broken in a way that they try to preserve human rights or the other international conventions. I mean, the greater good, the sins or other forms of legality, they're still trying to preserve even if the main rule of law is broken in some cases. As in Brazil, we are facing a major problem with judicial activism because most often than not, judges are breaking the rule of law to preserve their own political ends. For example, judges in the Supreme Court, because they are appointed by the political parties, in some cases they will decide against the rule of law because they try to preserve the political interests of the parties that nominated them. And that creates the issue that they should be the higher instance to protect the Constitution, but most often than not, they are not interested to preserve the Constitution and not. So my question is, did you see what kind of forms of judicial activism did you see during your judicial career?
Well, I mean, of course, we're very fortunate in this country that the judges are totally independent of the government. And I don't believe that any judge, certainly I never, felt remotely under pressure from the government to decide in favour of the government. That just doesn't happen, and there's a wonderful culture here of independence, and whatever one says about our successive governments, they recognise and understand that. I mean, Boris Johnson wants to change judicial review. Well, if he does, and he persuades Parliament to change the law, that's fine. I mean, when I say it's fine, it isn't fine, but I mean, that is our system. And then if Parliament changes the law, the judges will have to apply that law. But everybody understands that, and the government, when they lose a case, they tend to say, well, they're very disappointed. That's about as far as it tends to go. So we're very lucky in this country. As to judicial activism, I think that probably means that no judge will do anything other than, I believe, what he conscientiously and honestly, he or she conscientiously and honestly believes to be what the law requires. But of course, as we were talking earlier on about grey areas and so on, and particularly when it comes to judicial review, which is after all the thing that people are really interested in this topic.
When I became Chief Justice, I was very keen to develop ideas along with lots of other people to try to
get stopped, sorry.
public understanding, and especially.
That sounds like Lord Burnett, if I.
Sorry.
That's okay. Don't worry about it. So there are when it comes to, and in fact, I think I gave a lecture on this, which is one of the lectures in my other book, about. I mean, judicial activism is quite a kind of emotive phrase, activism. I mean, I think it's really, in what circumstances do the judges think that this is a matter for Parliament which is not for them, and in what circumstances do they think it's for them? And that comes into developing the common law, but it also comes into in what circumstances will the judges strike down a decision of the executive on the grounds that it is unlawful? And in what circumstances will they say, well, there's a margin of judgment for the government, and this decision, even if I don't necessarily agree with it, falls within the band of reasonable decisions, and so on. So there's a lot of judgment here.
Yeah, I'm just curious. I'm sorry to interrupt you.
No, sorry.
Well, I'm just curious if you find during your career some type of judge that they could easily justify breaking the rule of law based on a certain higher rule of morality. I'm fine to break the rule of law to protect the higher good, or some form of the higher good that they may think that is justifiable.
Well, we don't. Well, that's not our system. I mean, no judge would ever say, I think that breaking the rule of law is justified in this case because of some higher norm.
Mm.
The rule of law is the highest norm, and that is what we apply.
One last question.
Lord, I'm asking you one question from your judgment, that is Denton versus White, 2014. There you have said, while striking out any application, that is 3.9 of the CPR, you have said, the whole circumstances are taken into consideration. Could you briefly tell me what are these main circumstances you take into consideration?
I really don't think I can answer that question. First of all, I haven't looked at that judgment for about 5 years. And so I would have had to have notice of that and thought about it. I'm sorry to duck it, but I'm just not in a position to deal with it. Sorry. Perhaps we've got time for one more question instead.
Well, I've got another question. If someone has a burning,
I've just got a very quick question.
a quick question.
It's really about what you were saying with what the sound bites of government, and then the view of the former Speaker of the House about the need for a written constitution. Have you got a view about where you think that may start developing, about the need to have a written constitution in light of what's been happening with all the changes?
Big subject.
Well, that's again, it's a crystal ball gazer one, isn't it? Personally, I'm not convinced that having a written constitution will make much difference, because the written constitution will have to be expressed in very broad terms of a fairly general nature, and how you apply and interpret those principles will throw up the very same sort of problems and issues that we have currently with our unwritten constitution. And look at America. They've got a written constitution. I'm not sure that it has made life any more certain or easier for them. It certainly hasn't. And look at how their position on abortion, just to take one example. So having a constitution doesn't really lead to certainty or I think make the path of decision making any easier. That's my current take on it.
I think it would take quite a long time to arrive at a written constitution.
Yeah.
That's a slightly different issue. Well, before I ask you to thank Lord Dyson for his contributions, the extension of his thoughts that we find in his memoir, I'd like to just draw your attention to the next Judicial Conversation event. So if you've enjoyed this one, found this stimulating, I hope you'll come along to the next one, which is on the 23rd of April. It's a conversation with Paul Stewart. Now, Paul Stewart is a well-known commercial photographer whose portfolio of work ranges from portraits of pop stars to politicians, both domestic and international. And more recently, he took on a commission to make portraits of the first 3 presidents of the UK Supreme Court. Now, this commission was in part a celebration of the court's 10 years of operation. But I think it was a very fascinating and inspired initiative to begin a tradition of commissioning portraits of the presidents of the Supreme Court. So he's going to come to ials to talk about the process of producing portraits of these judges. And I think that's a very timely conversation that will enable us to think about how judges project themselves into the world and what messages they communicate. Because certainly one of the judges that he made a portrait of has recently been described as being a household name and is being chastised for that. So the more judges put their head above the parapet, the more likely they are to become objects of controversy, I think. So I think that's going to be a very interesting conversation where we can explore some of those issues. So
that leaves it to me to thank our panel for, I'm sure everyone will agree, an outstanding launch to our Judicial Conversations series. So thank you all very much, and thank you for coming. And please do stay to chat, continue the discussion informally over some refreshments. Thank you very much.